So hi everyone, how are you doing? Okay, so in the last class we have discussed about the Indian Contract Act till the section 227, and under that section we have discussed about the notice to the principal and notice to the agent, and we have also discussed that how the principal is bound only by the authorized acts of the agent, that in the sense where the certain acts or certain behavior is authorized by the principal to the agent. In that specific circumstances, principal is bound by those acts of the agent. Okay, that is what we have already discussed in the last class. Your next provision comes about the principal is not bound if the authority exceeded. And under that, I have already made you understand that when the agent acts beyond his authority, for example, you have been appointed as my agent and I have permitted you to do certain specific activities, but you are exceeding your limitation. For example, you are doing something for which I have not permitted you, but still you are doing that specific act. Okay, so you are not being bound within your authority, or if you are exceeding your authority, then in that specific circumstances the principal is not bound for that specific act. Okay, and in under section 228 this is what we have understood, that if the unauthorized activity cannot be separated from the authorized activity, then the whole activity will be considered as irrelevant. Let me make you understand how does it works. For example, as I have already we have discussed in the last class, there is the there is take an example of a specific situation. For example, you have appointed me as your agent to sell a specific car. Okay, so there is a another music system or another computer system is being attached in the car, which you have not permitted to sell. That means you have permitted me to sell the car only, not the another music system of the car. For that you have not permitted me. Okay, but what I am doing, without your specific permission, I am selling that specific system also. Okay, so here, if these activities are separated from each other, for example, at the first glance, I have sold the car, and at the second glance, I have sold the music system or that specific system of your computer system of your car. So these are the two sales I did separately. At the first sale, I sold the car, and at the second sale, I sold the computer system. So these are the two specific sale I did in a separate basis. Okay. So when I am doing the sale of two things separately, but where I have been permitted to do only one sale from my principal, from my owner, in that specific circumstances, my principal will be responsible for the specific sale for which he has permitted me. That means यहाँ पे मेरा जो ओनर है वो जिस एक्टिविटी के लिए मेरे को परमिशन दिया है, दैट मीन्स द सेलिंग ऑफ द कार फॉर which आई हैव बीन परमिटेड, अगर मैं वही कार सेल करती हूँ, then I will be get my amount of the compensation or my expenses for the specific sale, and I won't be responsible for the sale of the car because this had been instructed by the principal to do that specific act. प्रिंसिपल ने यहाँ पे जो है मेरे को वो एक्टिविटी करने के लिए इंस्ट्रक्ट किया था स्पेसिफिकली कि आपको ये करना पड़ेगा, एंड दैट इज वाई आई सोल्ड द कार एंड आई एम नॉट रिस्पॉन्सिबल फॉर द एक्टिविटी. बट ऑन द सेकेंडरी बेसिस, कार का जो कंप्यूटर सिस्टम था जिसी को मैंने सेल किया, उसके लिए आई डिडंट हैव एनी परमिशन टू डू सो, बट स्टिल आई सोल्ड द इंस्ट्रूमेंट. ओके, सो आई विल बी लाइबल ओनली फॉर दैट सेल, और उसी का जितना भी कंपेंसेशन होगा, आई हैव टू पे कंपेंसेशन टू माय प्रिंसिपल फॉर दैट स्पेसिफिक सेल बिकॉज द प्रिंसिपल हैज नॉट परमिटेड मी टू डू दैट सेल. So here there are two cells in nature. For the first sale, the principal will be liable, but for the second sale, the principal will not be liable at all. I, as the agent, will myself be fully liable for that specific activity. And under section 228, we have understood this is the provision I told under section 227. 228, we have understood if the two activities are non-separable from each other. So let me explain you that how these two activities are non-separable from each other. For example, I have told you that just take an example of this, that how the two activities has been non-separable from each other. That you are selling the car with my instruction that please do sell the car, and you are selling the car with with my instruction. But there is a system of the computer, there is a my computer system is attached in the car. So you are selling the computer system along with the car. But here there was the specific permission where it was mentioned that you have to sell only the car, not the computer system. But you are selling the attached computer system along with the car. So here this is a activity where one thing is permitted to say and sell and another thing has not been permitted to sell. But the scenario is the primary thing which has already been permitted to sell. It is closely attached, closely associated with the secondary thing which has not been permitted to sell. These two are non-separable in nature. यहाँ पे जो कार का कंप्यूटर सिस्टम था उसको कार का सिस्टम से अलग नहीं किया जा सकता. This is closely attached to the system of the car. Got it? So in these specific circumstances, the whole transaction, the principal will not be held liable and the agent will be fully liable for this act. Because यहाँ पे if the secondary activity is inseparable from the primary activity, then the whole act will be responsible for the agent only, not the principal. क्योंकि agent का यहाँ पे ड्यूटी क्या है? प्रिंसिपल का ऑर्डर मानना. अगर उसको ये चीज का पता चलता है कि कार का जो कंप्यूटर सिस्टम है उसी को कार से अलग नहीं किया जा सकता था, then it was his responsibility to inform this to the principal. वो प्रिंसिपल को इस बात का इंफॉर्मेशन दे सकता था. वो अगर चाहता था तो फिर कार का सेल को भी रोक सकता था. Because there was the system attached in the car which was supposed to be sold with the car. But here, without doing any specific activity, he permitted to do the sale. And hereby, the agent is liable for all the activities itself. Got it? Then comes your section 229. And here it mentions that the notice to the agent is called the notice to the principal. That means if there is a specific notice is being given to the agent, then it will be considered as the notice to the principal itself. Okay. For example, you are my customer, or you are a person who is working with a business course with me. So what is happening that you are supposed to transfer me certain informations. You are supposed to provide me certain kind of the informations. Okay. So as I am unavailable at the specific moment, you are passing the information to my agent. You are telling my agent about the specific information and you are instructing my agent to pass the information to me. So here, notice to my agent will be considered as the notice to the principal. That means यहाँ पे एजेंट को अगर किसी भी तरह का नोटिस प्रोवाइड किया जा रहा है, देन ये माना जाएगा कि वो नोटिस प्रिंसिपल को ही डिलीवर किया गया है. एंड अगर ये नोटिफिकेशन प्रिंसिपल के पास नहीं पहुंचता है एंड उसी के वजह से बिजनेस में किसी भी तरह का नुकसान होता है, then in that specific circumstances the agent is liable for that and he is liable or she is liable to pay the compensation to the principal for the losses occurred. Okay. Then comes section 230. And under that, we have discussed the agent is not personally liable for principal's contract. The agent is responsible for the contracts of the principal, but it is he is personally not liable to fulfill certain conditions of the contract, and he is not responsible for fulfilling the principal contracts agent unless and until the agent is personally liable under certain conditions. That means the if there is any kind of the contract that has been done by the principal, then the agent is not liable to follow the terms and conditions of the principal and to follow the specific members specific nature of the contract. Okay, so there are certain exceptions in which the agent can be liable for the contract of the principal. So what are those exceptions? The first point is if the agent acts for the foreign merchant. The second point is if the agent does not reveal the name of the principal. And the third point is if the principal cannot be sued. If there is any circumstances in which it is impossible to sue the principal is absent to be sued, then in that specific circumstances, the in that specific circumstances, we need to understand that the agent is not personally liable for the contracts of the principal. Okay. Then comes section 231. What does it speaks? Rights so an agent does not disclose the principal's name. What does it mean? The rights when the agent does not disclose the principal's name. So, what is the right of the agent when the agent is not disclosing the name of the principal? If a person dealing with the agent does not know the agent is acting for a principal, the principal can still enforce the contract. What does it mean? If a person dealing with the agent, अगर एक इंसान जो है, he is dealing with the agent and he does not know the agent is acting for the principal, उसको ये बात का अंदाजा नहीं है that the agent is acting for the principal only, then in that specific circumstances also the principal can still enforce the contract. Let me give you an example of this. For example, you have appointed me as your agent to do a certain activity or to do a specific business deal which is up to 30 lakh of the worth, which worth up to 30 lakh of the rupees. Okay. So, in your absence, you have appointed me to do that specific kind of the contract, and I went to that specific place. I did the deal. I signed in the document on behalf of you, and I did every single thing which you were supposed to do. So here, when I did all the activities over there, then it is the obvious thing that the person with whom I am doing the deal, that person will think that I am the original owner of the contract. But the person has specifically no idea that I am not the only person to enter into the contract. And the person has no idea that I am the person who is responsible to complete the nature of the contract. And I am here working as the agent of my principal. That person thinks I am the whole owner or I am the principal of the contract. But he or she does not have any idea that I am only acting an agent of yours for the specific nature of the contract. So when this is the situation, the agent does not the agent when the agent is not disclosing the name of the principal, एंड द पर्सन हु इज डीलिंग विद द एजेंट, एजेंट के साथ जो इंसान बिजनेस का डील कर रहा है, उसको भी इस बात का अंदाजा नहीं है दैट हु इज द रियल ओनर। वो एजेंट को ही बिजनेस का रियल ओनर मानने लगता है, एंड मोस्ट इफिशिएंटली he started doing the business with the agent. So in that specific circumstances, the principal still have the liability to take the benefits. And most importantly, the agent have specific liability to go with the contract or to complete and follow the terms and conditions of the contract. Okay, got it? So in all over under section 231, as we have understood that if the person dealing with the agent does not know that agent is acting for a principal only, then the principal can enforce it in the court. Okay. Then comes your section 232, which exactly speaks about the contract made with agent without knowing principal exists. Okay, so how does it been done? So under section 232, as we have understood, there is a new provision which speaks that if a third party makes a deal with an agent believing the agent is the actual party, the principal can claim the contract, but the third party retains any rights against the agent. Okay. So let us understand this. What does it specifically mean? If a third party makes a deal with the agent, अगर कोई तीसरा पार्टी है जो कि एजेंट के साथ किसी भी तरह का डील कर रहा है, बिलीविंग दैट द एजेंट इज द एक्चुअल पार्टी, ये मान के कर रहा है कि द एजेंट इज द एक्चुअल और ओरिजिनल ओनर इटसेल्फ, द प्रिंसिपल कैन क्लेम द कॉन्ट्रैक्ट। यहाँ पे क्या हो सकता है? प्रिंसिपल जो है वो अपना कॉन्ट्रैक्ट को ना क्लेम कर सकता है। ओके, देन व्हाट डज इट मीन? बट द थर्ड पार्टी रिटेन्स द राइट अगेंस्ट द एजेंट। बट यहाँ पे जो थर्ड पार्टी ना, हिज राइट्स विल बी रिटेन अगेंस्ट द एजेंट ऑलवेज। ओके, देन व्हाट डज इट मीन? इट मीन्स when there is a third party who is dealing with the agent, and the third party believes that the agent is the only principal or the agent is the actual party, then in that specific circumstances the principal can claim the benefits from the contract, but the third party retain rights, then the third party retains any rights the agent. Okay, got it? So then here comes section 234. Then comes section 233, which exactly speaks about the personal liability of the agent. And it is clearly provided under section 233 that at what circumstances the agent is not personally liable. Okay, okay. So next here comes section 233, and it exactly specifies when the agent is personally liable. Okay, if the agent is personally liable under a contract, the third party can sue either the agent or the principal or the both. This is an interesting fact. Let's understand this. If the agent is personally liable under a contract, अगर एक ऐसा कोई कॉन्ट्रैक्ट का नेचर है जहां पे this was not permitted by the agent to do so, permitted by the principal to do so, but the agent is still doing the activity. जैसे कि मैंने एग्जाम्पल दिया था, फॉर एग्जाम्पल आई हैव assigned you to do a specific deal in my business. Okay, so you had your specific genuine rights to do the course of business. Got it? But along with your task, You decided to work on something else. आपको और कुछ काम करना है, right? So here you will be liable for your personal acts for which I have not permitted it. जिस बात के लिए मैंने आपको परमिशन दी ही नहीं थी to do that specific task. So when if the agent is personally liable under a contract, then the third party, यहाँ पे जो third party है, जो customer है, the third party can sue either the agent or the principal or the both. Okay, that means how to give an example of this? Okay, let me give an example. For example, I was talking to about the selling of a house. Okay, for example, there is a home which has been sold. Okay, so there is a specific conditions of the home. There are certain instruments that is attached in the home which I have not asked the agent to sell. As the principal, I have denied the agent to sell those instruments and just to sell the home. But without my permission, along with the home, the agent sold all the other documents, all the other designs of the house, the agent sold it off. Okay. So when I am getting the information about this sale कि ऐसा ऐसा हो गया है, मतलब घर का जो सामान नहीं बेचा जाना चाहिए था वो भी सेल कर दिया गया है. ओके. सो व्हेन इट इज बीन हैपनिंग, जब ये हो रहा है कि एजेंट अपना सामान अपना मर्जी से विदाउट द परमिशन ऑफ द प्रिंसिपल दूसरा कोई सामान भी बेच रहा है, देन इन दिस स्पेसिफिक सर्कमस्टांसेस द एजेंट विल बी पर्सनली लायबल फॉर द एक्ट ऑफ द प्रिंसिपल. यहाँ पे एजेंट जो है ना प्रिंसिपल का इसी एंड यहाँ पे एजेंट जो है ना ही विल बी लायबल फॉर द एक्ट ऑफ हिमसेल्फ. यहाँ पे जो घर बेचने के लिए प्रिंसिपल ने उसको बोला था वो घर के साथ साथ सामान भी बेच दिया, तो घर बेचने के लिए कौन लायबल होगा? प्रिंसिपल लायबल होगा. और घर के साथ साथ जो सामान बेचा हुआ है उसके लिए कौन लायबल होगा? एजेंट लायबल होगा. So here, for example, after taking up the property, the customer who has taken the property, he is suffering any kind of the issue. Then in that specific circumstances, who will be liable for that specific circumstances? यहाँ पे उस चीज के लिए कौन liable बनेगा? Okay, so that means if the agent is personally liable under a contract, अगर जैसे कि मैंने बोला घर बेचने के लिए मैंने आपको एजेंट के हिसाब से हायर किया था, बट आपने विदाउट माई परमिशन घर के साथ साथ घर का कुछ सामान भी बेच दिए हो, then you are personally liable for that act under the contract. And the third party can sue either the principal or the agent or both. ये जो थर्ड पार्टी है ना, ये यहाँ पे either प्रिंसिपल को स्यू कर सकता है, एजेंट को स्यू कर सकता है, और दोनों प्रिंसिपल और एजेंट को स्यू कर सकता है, बिकॉज द थर्ड पार्टी हैज टेकन द हाउस. एंड यहाँ पे जो कॉन्ट्रैक्ट हुआ है, भले ही एजेंट विदाउट द परमिशन ऑफ द प्रिंसिपल वो कॉन्ट्रैक्ट किया है, बट ओरिजिनली जो ओनरशिप है ना, ओरिजिनली जो लायबिलिटी है वो किसके हाथ में है? प्रिंसिपल के हाथ में, राइट? If the agent is doing any kind of the disturbances in the deal of the contract, then who will be liable for the act of the agent? The principal will be liable for the act of the agent. And here, as we know that even if the principal is not liable for the act of the agent is, if the agent is personally liable for a contract, then the third party, he has the right to sue for the contract, firstly to the agent who did the deal, secondly to the principal with whom instruction we did the deal. Okay, and the third one, if the agent personally guarantees payment to a supplier, the supplier can sue the agent as well as the principal. Okay, got it. Then comes your section 234. Okay, okay. Then comes your section 234. which speaks about the including belief of the exclusive liability. Okay, so what does it mean? A third party makes the agent believe that only the principal will be held responsible. The third party cannot later hold the agent responsible. Okay, so what does it mean? If a, if a third party, it makes the agent believe that only principal will be held liable and the third party cannot later hold the degree anymore. Okay, then comes if a third party makes the agent believe that the only principal will be held responsible, the third party cannot later hold the agent responsible. Okay, got it. Then comes your section 235, which speaks about the liability of the pretended agent. Okay, so so when we are talking about the pretended agent, who is the pretended agent? Pretended agent means the person who is not the agent in real, but who pretends to be an agent. Okay. If someone falsely claims to be an agent and convinces the third party to enter into a contract, that person is responsible for for compensating the third party. So what does it mean? It means when we are talking about the liability of a pretended agent. For example, there is a person who is working as the pretended agent, who is not a original agent, but that person is pretending to be an agent of the contract. Okay, and that person is falsely claiming himself to be the agent. That person is not the original agent, but he is claiming himself that I am the agent of the contract. Okay, and the person is convincing the third party to enter into the contract, then in that specific circumstances the person is responsible for compensating the third party in a fraudulent manner. यहाँ पे जो एजेंट है ना, दैट पर्सन विल बी रेस्पॉन्सिबल फॉर कंपेंसेटिंग द थर्ड पार्टी. वो किस बात के लिए रेस्पॉन्सिबल होगा? थर्ड पार्टी को कंपेंसेट करने के लिए दैट पर्सन विल बी रेस्पॉन्सिबल. ओके, so here, if someone falsely claims to be an agent and convinces the third party, that means I am the agent of some specific person and I am convincing you to act on behalf of my principal, but in real I am not the original agent of that person, but in duplicate I am pretending that I am working as an agent of that specific person. So this is called the false agency. And when a specific person is falsely claiming to be an agent of a person and claims and convinces a third party, तीसरा कोई इंसान को, that person is convincing to enter into the contract, एक contract पे enter करने के लिए वो convince कर रहा है, then यहाँ पे ये माना जाएगा कि that person is responsible for compensating the third party. Okay, then comes section 236, which speaks about no right to enforce contrary to the false agent. Okay, so when there is the presence of the false agency, if someone acts an agent but actually acts for themselves, they cannot demand enforcement of the contract. Okay, for example, I have uh, I have been appointed as your agent, but as an agent, I am not acting for you. I am acting for my own self. For example, I am carrying my own business, okay? But I started working as your agent. So when I have been appointed as your agent, isn't it my responsibility to take care of your business or to handle your agency? But instead of carrying forward your agency, instead of helping you out in your agency, what I did, I started. enforcing the contract for myself. I started taking benefit for the contract for myself. Okay. So if someone acts an agent but actually acts for themselves, वो खुद के लिए काम करता है, उसका अगर 5% का प्रॉफिट है तो वो 30% का प्रॉफिट चुरा रहा है, then in that specific circumstances that demand enforcement will be a contract. Okay. Then comes section 237. Then it is clearly told that the liability of principal induced the burden. Okay. The induced the belief itself. Okay. If the principal allows the third party to believe that the agent has authority, the principal must honor the agent's activity. That means if I am the principal, I am appointing you as my agent and I am instructing you to authorize a specific contract. I have been giving you an appointment, or I am permitting you to do certain kind of the signatures, or to I am giving you the full authority to enter into the contract, to sign the contracts. So in that specific circumstances, the principal must honor the agent's activity. मैंने आज यहाँ आपको एक मीटिंग के लिए और एक बिजनेस डील के लिए आई हैव बीन अपॉइंटेड यू एज माई एजेंट and I permitted you that you should go to that specific place, sign the documents that is been required and handle the course of the business. And you started working for me. आपने मेरे लिए काम करना शुरू कर दिया. So when you started working for me in that specific circumstances, it is clearly seen that I am handling the course of business instead of you. And here it is your responsibility. It was your duty. Okay. What to do? It was your duty to respect and to honor the agent's activity. That means if the agent has done any kind of the specific activity with the permission of the principal, how is it? For example, if the agent has entered into the contract, or if or the agent has done any kind of the signature, and specifically in the business deal the agent has taken any kind of the important decision, it should not be act on behalf of the principal, that the principal should avoid that activity, the principal should ignore that activity. It is the duty of the principal to take care or to be responsible for the activity of the agent. That means it is the duty of the principal to be conscious for the act of the agent and to act carefully for the act of the agent. If the agent has taken any kind of the decision, if the agent has entered into any kind of the contract, so the principal should welcome that specific activity, to honor the specific activity and to respect that specific activity. Then comes section 238. It speaks about the misrepresentation or fraud by the agent. This is the last section upon the sub-agent and concept of the agency. So, when we are talking about the misrepresentation or fraud by the agent, what does it speak? It is explained under section 238, and it has been mentioned here that if an agent commits the fraud or misrepresentation while conducting the principal's business, the principal is responsible as if they committed it by themselves. It means if the agent has committed the fraud, the agent has committed any kind of the illegal activity. For example, he did any kind of the theft, misrepresentation, mistake, or he had cheated someone. He took money from any unlawful sources. Got it? So he did the activity of the fraud, और he did activity of the misrepresentation. फ्रॉड का मतलब क्या है मैं आपको समझा चुकी थी. जहाँ पे आपको पता है, यू नो दैट इफ आई एम गोइंग टू डू दिस एक्ट, then this activity is going to harm someone. आपको इस बात का क्लियरली अंदाजा है कि आपका एक्टिविटी किसी को नुकसान पहुंचा सकता है. You are clear about this. You know that your activity is going to harm somebody, but still after knowing that you are doing that specific activity, and this is called fraud. जहां पे आपको इस बात का अंदाजा है कि अगर किसी भी तरीके से कोई स्पेसिफिक एक्टिविटी किया जाता है, then how it is going to affect the third party. अगर किसी भी तरह का एक्टिविटी किया जाता है तो वो थर्ड पार्टी को किस तरीके से अफेक्ट करेगा, उस बात का पूरा अंदाजा आपको है. But even after knowing that you are doing that specific activity, this is called the activity of the fraud. And what is misrepresentation? Misrepresentation means you know that there is a specific deal which is worth up to 30,000 of the rupees, but you are misrepresenting the third party. Instead that you know that the deal will cost up to 30,000 of the rupees, you are doing the deal with 50,000 of the rupees, because the person who is doing the deal, he doesn't have the specific idea about the actual price. He doesn't know about this, and you are taking the benefit of that. And taking the benefit, you are doing the deal with the amount of 50,000 of the rupees. This is called the misrepresentation, where you are not representing something in a specific manner which is actually valid, which is actually true. You know that there is a specific activity which is valid in nature, but instead of proving that, instead of doing that valid act, you are doing it in a wrongful manner. That is called the misrepresentation, where you are representing something in a miscellaneous way, in a fraudulent manner, in a non-authentic manner, which is not valid at all. So when there is a fraud or misrepresentation while conducting the principal's business, then in these specific circumstances, the principal is responsible if they committed it by themselves. Okay, that means the principal is responsible if, okay, the principal is activity over here for the act of the agent, but here according to the law, the principal can be compensated from the agent separately. यहाँ पे जो प्रिंसिपल है ना, वो एजेंट से सेपरेटली कंपेंसेशन ले सकते हैं, बट हियर इट इज द प्राइमरी ड्यूटी ऑफ द प्रिंसिपल टू compensate the third party who has been suffered by this activity. एजेंट का ये मिसकम्युनिकेशन या मिसरिप्रेजेंटेशन या फ्रॉड के वजह से अगर किसी भी तरह का नुकसान हो चुका है, then that kind of the loss in the course of the business, okay, it has to be taken care by the principal in a primary circumstances. Later the principal can claim the compensation from the एजेंट फॉर दैट स्पेसिफिक एक्टिविटी. बाद में प्रिंसिपल जाके एजेंट को स्यू कर सकता है कि आपका खामखियाली के वजह से या आपका ये एक्टिविटी की वजह से मेरे को नुकसान हुआ, सो यू हैव टू कंपेंसेट मी. दैट इज अ डिफरेंट थिंग, बट वी हैव टू टेक केयर दैट अगर प्रिंसिपल ने यहाँ पे पहले हु इज रेस्पॉन्सिबल एट ए फर्स्ट ग्लांस, द प्रिंसिपल इज रेस्पॉन्सिबल फॉर द एक्टिविटी ऑफ द बिजनेस, एक्टिविटी ऑफ द agent. Agar there is a, for example, there is a big shop, okay, so what is happening that in the specific shop the principal has kept 3 to 5 salesmen in the shop. So those salesmen are doing their own course of business and they are doing the duty in the shop. So they, what they did, they lied to a customer. वो एक customer को झूठ बोले about a specific product. and they sold that product. So this is the act of the fraud, जहाँ पे एजेंट को इस बात का पता था कि हाँ, ये चीज जो है, अगर मैं इसी को इस मतलब बता रही हूँ कि ये प्रोडक्ट सही है, तो ये गलत है. एक्चुअली दिस प्रोडक्ट इज नॉट गुड फॉर द हेल्थ, बट स्टिल द सेल्समैन इज सेलिंग दैट प्रोडक्ट विथ रीजनेबल प्राइस. ओके. मिसरिप्रेजेंटेशन क्या है? जहाँ पे एजेंट को खुद पता नहीं, द एजेंट इज बिलीविंग द एक्ट टू बी ट्रू, जो कि सच नहीं है. सेल्समैन को लगता है देर इज ए प्रोडक्ट विच इज कॉस्ट अप टू 300 रुपीज, बट उस बटल का एक्चुअल कॉस्ट है 200 रुपीज, बट सेल्समैन को ये लग रहा है कि इसी का प्राइस है 300 रुपीज. तो उसने क्या किया, कस्टमर को 300 पे बेच दिया. ये है मिस रिप्रेजेंटेशन. यहाँ पे कोई फैक्चुअल जो है, जो सामने वाला मतलब जो कॉन्ट्रैक्ट साइन कर रहा है, फिर जो जो सामान दे रहा है, उसको इस बात का, वो जानबूझ के ये गलती नहीं कर रहा है. अगर जानबूझ के कर रहा है तो वो हो गया फ्रॉड. अगर बिना जानबूझ के वो गलत फहमी में है कि ये चीज का इतना प्राइस है, ये चीज इस तरीके से हो रहा है, जो उसको लग रहा है वो अपने हिसाब से कॉन्ट्रैक्ट कर रहा है. सो दिस इज कॉल्ड मिसरिप्रेजेंटेशन, जहां पे मेरे को कोई चीज का गलत फहमी है. सो फॉर एग्जाम्पल, मेरे को एक बोतल का, देर इज ए बोतल आई एम सेलिंग, and I believe that the price of the bottle is 300 rupees, but the actual price is 200 rupees, and I am selling the bottle to the customer with the price of 300 rupees, with the misrepresentation that the bottle is cost at 300 rupees. Or else I know that the price of the bottle is 200 rupees and I am still selling it with the price of 300 rupees, and that is what I am doing the act of the fraud. So, as I have been appointed by my principal as the agent to do that activity, and I am doing this kind of the fraud or misrepresentation, so hereby I will be responsible for that activity, as well as my principal has to give compensation to my customers. यहाँ पे प्रिंसिपल जो है उसी को कंपेंसेट किसको करना पड़ेगा, कस्टमर को कंपेंसेट करना पड़ेगा. बिकॉज हियर कम्स द कंसेप्ट ऑफ द मास्टर सर्वेंट लायबिलिटी अंडर द लॉ ऑफ टॉट. द मास्टर इज लायबल फॉर द एक्टिविटीज ऑफ द सर्वेंट इन द कोर्स ऑफ बिजनेस. यहाँ पे जो एजेंट है, मास्टर का यहाँ पे जितना लॉस हुआ, जितना कंपेंसेशन वो दिया है, द एजेंट इज लायबल टू पे द कंपेंसेशन टू द प्रिंसिपल ऑन ए लेटर स्टेज. But here the principal is responsible to compensate the customer for their losses or for their damages occurred, even if the activity has not been done with the permission of the principal, but it has been done under the course of business of the principal and under the authority of the principal, and that is why the principal is liable for the act. Clear? So this is about section 238 of the Indian Contract Act. In the next class, we are going to start a new provision, that is about the bailer and the concept of the bailee. Okay. So this is all for today's class, guys. Is there any doubt? We can drop the class over here. Thank you. Bye bye.